taking the time to join us this evening. My name is Steve Glazer, and I'm the director of the School of Continuing Education at Naropa. I'd like to welcome you all, and especially welcome Lennox Hinds, who's joined us all the way from New York. And a special thanks to Denise Baker in the front row here. And if not for her hard work, this would not have happened. I met Lennox a few weeks ago at the Harvest Restaurant on the Pearl Street Mall, and we spoke about the OJ trial, and in particular about the moment that America stopped to hear the verdict. America stopped, Boulder stopped, commerce, traffic, stairmasters. Everybody's ears were on the radio, their eyes were on TV. As powerful a moment as it was really like the tip of an iceberg. Most of the power, the bulk of the issues, political issues, cultural issues, anger, confusion, were still submerged, really very deeply under the surface. And so while the flash and the heat of trial have drifted away out of consciousness, off the radio, out of the front page, these political, judicial, and racial issues still lurk and are really right there in our lives. So in the Naropa tradition of starting from where we are, recognizing what is and facing it, we invite Professor Lennox Hinds up to speak to us, to speak with us, and help us explore the depths of ourselves, our culture, laws, and community. Thank you.
I'd like to thank Steve, the School of Continuing Education at Naropa, for sponsoring this this evening and for inviting me here. I'd also like to thank Charlotta, is it Carlotta or Charlotta? Charlotta and Michelle, and also Denise, for their efforts in getting me here safely and on time. I was looking at the Weather Channel in New York this morning, and I was told that there would be 3 inches of snow on the ground here in the Denver area. And I said, my God, I wonder if this new airport that they've built will be shutting down, or would it hold up? But I'm impressed with the warmth and hospitality that has been accorded me here since I arrived this afternoon. I met with the president and had some discussions with him. And the student body here at Naropa is a warm student body. You feel as if you're part of a family. In 1900, William Edward Burghardt Du Bois defined the problem, as he saw it then, the problem of the 20th century, as the problem of the color line. In short, problem of race. Today, in 1995, the increasingly intense and polarized public debate concerning the criminal justice system and its capacity to achieve justice, triggered by the O.J. Simpson trial, certainly supports Du Bois' prognosis. And I may add, my own experiences, my career as a black lawyer, as a law professor, and my life as a black man in America supports the prognosis. There was much talk after the verdict about race cards and sharp comments about a surprising difference in perceptions, about the legal system and the perceptions between white and black people. Tonight, I hope we will focus and discuss on some of these differences of perception. Tonight, I invite you to look at the administration of justice, and let me take you on a journey looking at it through my eyes. or those of any other person of color, whether they be Chicano, Native American, Asian American, as compared to the perspectives of Euro-Americans. My expectations of the law as an objective instrument by which justice is done and seen to be done is informed not only by my role as a practitioner in the system, but inevitably by my treatment in the system as a black person. And believe me, there is a thin line between my standing in front of the bar and that's the swinging gate that separates the observers in the courtroom from the actors. There's a bar that separates the audience, people who are watching the trial, and the prosecution, and the defense, and the defendant. And there's a bench. And behind that bench sits the judge. And then there are court officers all around. But there's a thin line that separates me standing at the bar and my brothers and sisters behind the bars. And many times there is not much difference as perceived through the eyes of those who administer the system between me and my clients. I've appeared before white judges in courts where I've represented white clients. The judge addresses his remarks to my client, and he looks at me as if I'm the defendant. Now I think that when I walk in to a courtroom, dressed in my bow tie, I think I look like a lawyer. Whatever lawyers are supposed to look like. Unfortunately, the perceptions of the criminal in America looks like me in terms of color, or any person of color. If we are dealing with Boulder, it may be Chicano or Native American. Let us consider the case of Susan Smith. You remember Susan. Susan was convicted of infanticide. Now, no one questioned Susan's anguish when she repeated over and over again that the abductors of her two children was a young black male wearing what? A ski cap. It fit the community's expectations. The sketch, police artists began sketching feverishly, and they were drawing all types of black males. Patrols went out, and they were relentlessly looking for a black male, until many days later, Mrs. Smith confessed to the crime. Now, I'm persuaded that the rage against Mrs. Smith was as much against the exposure of the community's racist assumptions as it was against the severity and depravity of her crime. Similarly, in Boston in 1989, and I don't know if you read about these things out here, close to the Rockies, but a man by the name of Charles Stewart accused a black man of murdering his pregnant wife, Karen. He claims that while he was driving through a deserted street in the Mission Hill, which is a black community in Boston, inner city neighborhood, that a black male came out, shot him, killed his wife. No one questioned his accusation. And they proceeded the police proceeded in a dragnet fashion to round up suspects. In fact, a black man by the name of Willie Bennett was arrested, charged with murder, and would have been convicted. But Charles Stewart's brother had a pang of conscience. Came forward and he said, look, my brother committed this crime. Now what happened to Willie Bennett? Willie Bennett was subsequently released. Of course, Charles Stewart jumped off a bridge and committed suicide. Now, Willie Bennett attempted to obtain some relief for his false imprisonment, malicious prosecution. And in America, that relief is obtained by way of a civil suit. You sue for what is called the pain and suffering. The wrongful act committed against you. And the theory being that money would place you in a position that you were in prior to being shackled, handcuffed, and hauled away and placed in a cell. Well, just a few days ago, the jury, white juries, hearing the case, found that the police were not at fault, and that Mr. Bennett, Willie Bennett, simply did not have a case. Are we really surprised that black people routinely fear the very law enforcement officers that are sworn to serve and protect this society? There is a difference in the perception and the reality of the role of the police in a community such as this here, as perceived through the eyes of people of color and others. The police are not seen as friends. Those individuals who, when you see Officer O'Reilly, he is not perceived by people of color as someone who comes with a lollipop and helps you cross the street. Those who have had encounters with the police or have seen others having encounters know that the police are not friends. And so therefore, there is a dichotomy that develops. Even people of color who are police officers run the risk of being perceived by their colleagues as criminals. In New York City and across the country, there have been black police officers who have been attempting to apprehend criminals. But if you see someone of color running down the street with a gun in plain clothes, there isn't a perception that that person may be a police officer. Even to other police officers. And so therefore, they end up being shot and maimed. So tonight, when I leave this podium, and I, for example, were to walk out to, what's the name of the street here, Arapahoe? Or perhaps even if I went down to the other main street, the main drag here, Pearl Street. There is no sign on my back that's stenciled saying lawyer. I could very well become a statistic. And in your local newspaper, tomorrow morning, Lennox Hinds, while attempting to open the door of his rental car, was stopped by the police who mistook him for a car thief, praying in the area. In the ensuing melee, while resisting arrest, Hinds was shot, suffered a heart attack. All of these things can happen. But maybe those things don't happen in Boone. But in New York City, in New Jersey, California, Pennsylvania, it happens frequently. Just last week, a Pittsburgh coroner's jury of 6 people, 3 white, 3 black, recommended that 5 white police officers be charged with homicide because a young black man, Johnny Gamage, was suffocated after a fight in police custody with the 5 officers. Now here is a man who, Mr. Gamage, who just happened to have been driving a Jaguar. He was stopped, and his demeanor was not what the police thought it ought to be. I generally say to my students, when I teach criminal law, I tell them that the Constitution of the United States accords you certain protections. You have a 4th Amendment right to be secure in your person from searches and seizures, except if supported by probable cause in a warrant. But if a police officer stops you, do not say to the police officer, I know my 4th Amendment rights. Those are fighting words. Don't say, I know the Constitution. You now have thrown down the gauntlet. These rights are enshrined in the document called the Constitution. But on the streets, they are illusionary. And so therefore, this young man, Mr. Gamage, ended up receiving 20 massive bruises, being hit by flashlights. And the police threw him down to the ground. One officer had his knee on his neck and then stood on his neck. His face was down on the ground. When asked, well, why did you continue to stand on the man's neck? Well, he kept flapping his hands and kicking. Well, is it possible that he was fighting to breathe? Mr. Gamage died. The coroner's jury recommended that the 5 police officers should be tried for murder. On the other hand, the prosecutor has said, let us not try this case in the press. We're not quite sure. The coroner's jury is not a grand jury. They only heard evidence with respect to the cause of death, and they said it is a homicide, but there are some other facts that we need to look at. Different perception given the victim being black. When I landed here today, I looked at your Denver Post article, and I noted that there was a settlement in the amount of $750,000. Rising out of the state police in Colorado, pulling over, stopping illegally without probable cause motorists traveling on your highway. What is the highway called? I-70. Is that the highway here? Okay. Some of you folks travel on it? Okay. The risk you run if you have tinted windows. If you happen to be someone of color and tinted windows, you got a problem. The police said that they had information from other law enforcement agencies that suggested that individuals who have radar detectors, visible air fresheners in your car, fast food wrappers on the floor. Now, give me a break. These were, they claim, some of the factors they looked at in pulling people over. But of the 400 individuals that they pulled over, the majority happened to be black. The laws in any society reflect the normative values in the society. They're not carved in granite, molded in steel. They're not handed down from the mountaintop by a bearded deity on a marble tablet. These norms are defined by the values we have within the society. And people, whether they be on the bench or in the legislature, define rules that codifies these norms. And there's a connection between the law and politics. Just over 20 years ago, women were denied control of the reproductivity of their own bodies. These decisions were made by whom? Men. Women were to be seen but not heard. They could be in the bedroom but not in the living room. And women had to struggle to change the law until Roe versus Wade legalized their choice. Today, as we sit here, the Republican majority in the Congress, with their contract on America, are planning now to put doctors in jail if they perform abortions before the first trimester. I'd like to talk a little bit about the draw your attention to the disparate and disproportionate sentencing meted out by the federal government in the prosecution of offenses involving drugs, and in particular crack cocaine, compared to powdered cocaine. Under the current law, there's a mandatory minimum sentence of 5 years for possession of 5 grams of crack cocaine. If someone has 500 grams of powdered cocaine, the same 5 years. A ratio of 100 to 1. And this also applies to the sentencing, which ends up with black men from the inner cities, where crack is common, doing long sentences in jail, and correspondingly lenient treatment for white suburban residents who are more likely to be using powdered cocaine. According to the United States Sentencing Commission, 90% of those convicted last year for federal crack offenses were black, and only 3.5% were white. Earlier this year, the Federal Sentencing Commission proposed removing the disparity in sentencing for drug possession. But the Justice Department opposed the change, and Congress passed a bill rejecting the proposal. Now, the Supreme Court has agreed to decide whether the federal government must explain why nearly all those prosecuted for federal crack cocaine offenses are black. The grounds for such a challenge, of course, is selective prosecution. In fact, according to the Sentencing Project, such drug arrests are the main reason a third of young black males are prisoners, parolees, or under some form of court supervision. Now, given these facts, are we still surprised that whites and blacks perceive the administration of justice differently? Is it hard to understand that after 130 years since the Emancipation Proclamation allegedly freed the slaves, African Americans frequently point to the law as the oppressor rather than their salvation? If we have a brief survey of the history of the United States and its legal system, it could help us understand the duality between the perspectives which people of color view the legal system and those perceptions that informs the views of Euro-Americans. The facts of how Africans became dispersed throughout the colonized world is well known. The intimate connection between law and African American status in the United States is less well understood, as is slavery's pervasive hold on their status to this day. The first Africans taken forcefully from their homeland in colonial America to colonial America arrived in Jamestown in 1619. Within 40 years, the Africans brought to America, those Africans brought to America had become a group apart, separated from the rest of the population by law and custom, legally classified as slaves for the rest of their lives, a status which was inherited by their children. They were forbidden to contract, forbidden to learn, forbidden to intermarry with whites, deprived of the African traditions, and dispersed among southern plantations. Blacks in America lost tribal, regional, and family ties. Chattel slavery, as it developed in the United States, laid the foundation for black people's perception of the institutional and legally sanctioned racism in the daily life of our society and in every courtroom in the land. In the United States, it is the law, supported by military might and political tyranny, which was the primary instrumentality that advanced the political purposes and economic ends of those in power. European colonists arriving in the new continent established laws which supported their expansionist intentions to exploit the resources of the New World. It was the law that stripped property from the indigenous populations of the North, Central, and Southern America. It was the law that defined the status of African Americans as chattel goods, as property. Chattel slavery was sanctified by law, both civil and ecclesiastic. After years of struggle, most of the explicitly racist laws have been overturned. But although African Americans, Native Americans, and Asian Americans are no longer legally barred from testifying against whites, pervasive institutionalized racism survives in the criminal and civil law. As we examine the reality and practice of the law, we observe customs favoring the rich over the poor, favoring white over black, brown, red, or yellow. The discretionary operation of the law continues to condone the exploitation of our Spanish-speaking brothers and sisters and other people of color as cheap labor sources. It is racism that allows lawmakers to pass racist laws, prosecutors to enforce them, and judges to sanction them. Past injustices survive in contemporary forms. Throughout the history of this nation, aggrieved peoples of color have attempted to expose the contradictions posed by the words of the founders of the nation when they announced to the British Parliament and the world, and they said, "We hold these truths to be self-evident, that all men are endowed by the Creator with certain inalienable rights, that among these rights are life, liberty, and the pursuit of happiness." As you must know, the European founding fathers had no difficulty reconciling the fact that most of the authors of this declaration were slaveholding property owners, including George Washington, Tommy Jefferson, Ben Franklin, all of them slaveholders. And they were founding a nation in which no black person or any woman had any civil or political rights, as they founded a nation on a continent stolen by deceit and armed violence from the indigenous Native American people. As they were uttering these self-righteous and deceitful words, they were looking in the faces of over 750,000 African slaves, and they were standing on land stolen from the indigenous people. It was the United States Constitution, Article 1, Section 2, Clause 3, which counted each enslaved African as 3/5 of a person for the purpose of determining the number of elected representatives for which each state was eligible. The law has defined and continues to define the interests and rights of people of this society. It still defines status depending on which side of the legal opinion you lie, whether you're a defendant or a prosecutor, whether you're a landlord or a tenant, whether you're a debtor or a creditor, whether you're a man or a woman, whether you're an adult or a child, whether you're a police officer or a citizen. Depending on which side of the opinion you are on, you are defining your reality either as part of the American dream or part of the American nightmare. Now, I began the discussion this evening with a question: can a black man receive justice in the United States? We might also ask, can a poor person receive justice in the United States? Our discussion tonight has focused only on the criminal justice system and has not even touched upon social and economic justice in respect to the availability of education, the availability of housing, and employment for poor people, a disproportionate number of whom are black, Latino, and Native Americans. Tonight we can only make the observation that institutionalized racism and this nation's condemnation of the disparity of the treatment of people of color and poor people since its founding has laid the foundation for the current crisis of mutual rage and suspicion, which increasingly divides our society at every level. The operation of the criminal justice system has always provided an easy barometer of this divide of power. Nothing is more obvious than the index of racism than the imposition of the death penalty. And the death penalty is imposed as a remedy for criminal conduct and as a method of social control. The permanent domination of enslaved Africans and their relegation to subordinate positions in society was clearly the intention of race-specific criminal laws in the 19th century. Louisiana gave jurors the discretion to sentence slaves to death for grievously wounding a white person, merely shedding the blood of the master, a member of his family, or the overseer, and for the third offense of striking a white. In Alabama, a black perpetrator or accessory could receive the death penalty for insurrection or rebellion against whites, attempted murder, rape, attempted rape of white women, burglary or arson, murder of a slave by another slave or freeman, however, was not punishable by death, but rather by branding of the hand or 100 lashes. In Virginia, the discrepancy between punishments for slaves and whites was even greater. Virginia laws contain over 70 potential capital crimes for slaves and only 3 for whites. In addition to the racially disparate substantive criminal law, rules of criminal procedure restricted the rights of black defendants. Even free blacks in all but 2 southern states were prohibited from testifying against whites in court, thereby preventing them from seeking redress for crimes against them. Slaves could testify against other blacks, but could never testify against whites in any court. No slave states allowed blacks to serve on juries, whatever the race of the accused. The dual system of justice did not end in 1865 with the Civil War. Following emancipation and the passage of the 13th Amendment, former slave states enacted the black codes as a substitute for the slave codes. The rhetoric of the 14th Amendment was an effort to inhibit the South's continued repression of its newly made black citizens. But judicial interpretation by the Supreme Court ensured the perpetuation of racially disparate justice and eliminated equal protection under the law for black people. When legal means were unavailable to enforce the subjugation of African Americans, extra-legal methods were developed. By extra-legal methods, I'm talking about lynchings. During the Reconstruction period, that is the first Reconstruction period, that is during the period when there were black governors, members of Congress, whites claimed that blacks were an uncontrollable danger to white society. Lynching arose as a means of terrorizing blacks. In both the South and North, lynching became a second method of capital punishment, aimed chiefly at whom? At black citizens accused of crimes or minor indignities against whites. Prominent white citizens and elected officials continued to defend lynching as a necessary replacement for the black codes, long after whites had recaptured complete control of the Southern legal system. In fact, lynch mobs, although nominally outside the law, often worked with its cooperation. The presence of lynch mobs often encouraged or forced the authorities to conduct hasty trials and exacerbated the prejudice of the entirely white judiciary and jury pool against the defendant. After a court of law pronounced a defendant guilty, it was not uncommon for a mob to administer his sentencing by hanging or some more brutal means such as burning, mutilation, or shooting. Lynchers, on the other hand, were rarely punished. The South also used legal means to maintain social control over blacks. After the black codes were outlawed, southern states adopted a criminal system which, while facially neutral, allowed prosecutors, judges, and jurors broad discretion to mete out widely varying punishments. In addition, some statutes which expressly discriminated on the basis of race remain. For example, up until the 1960s, Virginia had anti-miscegenation laws. The landmark case of Loving versus Virginia, involving laws that were on the book, which criminalized blacks, whites, black and whites, intermarrying. In addition, some statutes which expressly discriminated on the basis of race remain. Despite the end of slavery and the adoption of the 14th Amendment, southern states continued to subjugate their black populations through the criminal law. Southern states also expanded their capital statutes to include many of the crimes previously contained in the black codes. For example, the crimes of burglary in the night, arson to an occupied building, and horse stealing, considered typical of free men, were made punishable by death, imprisonment or fines at the discretion of the prosecution, the court, or the jury. Rape and insurrection also continued to be punishable by death. Courts regularly applied the facially neutral sentencing statutes in a racially disparate fashion. The legal system didn't treat similar crimes by whites in a similar manner. Whether black defendants suffered at the hands of a mob or the law, they were treated more severely than similarly situated white defendants. Meanwhile, lynching or the threat of racially motivated violence was used in an attempt to control African Americans, almost as effectively as a race-specific criminal and civil code, as slavery itself. Discriminatory application of criminal punishment avoided the constitutional requirements of the criminal law. The passage of the Civil Rights Act of 1875 was an effort to redress some of the inequities of the criminal justice system run by and for white people. Although the act prohibited states from excluding qualified persons from a jury on the basis of their race, unequal justice thrived. Blacks were frequently described as having failed the suffrage test and therefore were unable to qualify for jury service under the law. The exclusion of blacks from the jury selection continued in the South for the next 50 years, in part because blacks were not permitted to register to vote. Jurors were drawn from voter registration lists. Consequently, disenfranchised black citizens did not appear on the jury roster. Hence, black defendants faced an entirely white courtroom. The judge, the prosecutor, the jury were all white. Of equal importance, exclusion meant that blacks in the community at large were denied their right to participate in the community's legal process. After the Second World War, African Americans, joined by other people of color, and white supporters began organizing systematic attacks on official de jure and de facto segregation. By the middle of the 1950s and continuing into the 60s, federal legislation was passed to remedy some forms of discrimination in the areas of public education, such as in the areas of public accommodation, transportation, voting, housing, and employment. However, as in an earlier period, the area of criminal justice remained a fertile ground for the retention and the growth of the problems flowing from racially disparate standards and discretion tainted with racial animus. You recall that there were 3 civil rights workers, Cheney, Schwerner, and Goodman, who during the civil rights period the 60s had traveled to a place called Mississippi, Neshoba County, Mississippi, in an attempt to register people to vote. And in the case books, there's a case called United States versus Price. And in reading, students reading that case book on constitutional law would not understand the background behind that case. And that case illustrates the frustration black people had within the system. Both victimized by being brutalized and oppressed in the system, and then getting no relief under the law. And also, if accused, not being able to get a level playing field. These three workers, called civil rights workers, 2 Jews and a black man. The 2 white young men were from the north, from New York City. And they went into Mississippi, registering individuals to vote. The locals, including the sheriff, local sheriff by the name of Price, local judges, lawyers, businessmen, viewed these individuals as outside agitators to be taught a lesson. They were killed, these 3 young men, and they were buried in a dam. Then President Johnson attempting to, first of all, law enforcement officials in the state of Mississippi were not about to spend much time looking for them. The case took on national and international dimension, forcing the federal government to call in the National Guards. These individuals were arrested. These individuals were found in the dam. But then the question was, who was responsible for the crime? Grand juries were assembled. There were about 13 individuals who were identified. Not a single one of those individuals were indicted by a state grand jury. The view of the locals were these individuals who were killed were looking for it. They were agitators. And we're not going to indict any of the good citizens of Neshoba County, Mississippi. It took the federal government to bring the federal prosecution. And then only 2 out of 13 individuals were convicted, including the local sheriff by the name of Price. But in terms of how the law operated, it's another case called McCorder versus State, which was a case involving an alleged attempted rape in Alabama. Mr. McCorder was standing on a corner. A white woman and 2 children, 2 or 3 children, were walking towards him. He was in a pickup truck. McCorder admitted that he was imbibing that evening. He was drinking. Little moonshine. The woman walking past, he's standing by his truck after working in the cotton fields all day. He said he was waiting for a friend. She saw him standing there, became alarmed and afraid. And she said to the children, "Run." And they had to run past him to go to a neighbor's house. And she said, "I just had a feeling that he was about to do something. And she said that when she passed, he began to follow her. And she quickly ran into the house and called the neighbor, and he came out. And by this time, McCorder, when they came out, McCorder was standing on the corner at a lamppost, watching them. They called the police. He was arrested, charged with attempted rape. Convicted of attempted rape. Certainly not by a jury of his peers in Alabama. Now you have to understand that in the United States between 1930 and 1960, there were 455 men who were executed for rape in the United States. 405 were black. In that same time period, blacks were making up just about 11% of the population, yet 54% of all of the people executed were black. Black defendants are sentenced to death more frequently than whites, who are convicted of the same or more heinous crimes. Crimes against white victims are more likely to result in death sentences than identical crimes against black victims. There is an unequivocal and unchallenged body of evidence demonstrating racial discrimination in the imposition of the death penalty. And notwithstanding that, the Supreme Court's recent opinions, especially in McCleskey versus Kemp, continue to show callous indifference to the proofs of obvious systematic racism in the application of the death penalty. Statistics concerning the imposition of the death penalty on blacks who kill whites as compared to whites who kill other whites or blacks is but one example. The inability to find redress in domestic law for these continuing violations of human rights of people of color in the United States suggests to many of us that we should be considering taking our cases to an international court. It is with this historical analysis and background that we should consider the case of the people of the state of California versus O.J. Simpson, about which so many are distressed. Actually, it seems to me that what has caused such a hue and cry is the black reaction to the verdict as compared to that of most white people. No communal event in recent history or memory encapsulated the racial divide between white and blacks concerning the perception of the criminal justice process and its capacity to function fairly and even-handedly. I find the reactions to the verdict extraordinary and as racially specific as anything that I've experienced in my life, particularly the attacks on the jury and therefore the jury system. Putting aside the discussion of the general racism of the law, any rational examination of the prosecution of the Simpson case in light of the fundamental constitutional principles of criminal procedure within our jurisprudence supports the verdict without any difficulty. Yet, throughout the land, there's talk of changing from a unanimous verdict, jury verdicts, to majority verdicts. That would not have changed the reality in that case. In fact, there are 2 states that now have non-unanimous verdicts. The state of Oregon, and there's a landmark case of Apodaca versus Oregon. And then there's another state of Louisiana where there are non-unanimous verdicts. and that the Supreme Court upheld the constitutionality of that in Birch versus Louisiana. But wouldn't have changed the reality at all in the case of the people of the state of California versus O.J. Simpson. Yet we hear a lot of talk about changing from a unanimous verdict to majority verdicts and other tactics, which suggests serious intentions to erode away the very constitutional principles of law, which are the hallmark of democratic values of our society. Now, chief among those principles within our jurisprudence is that no one accused can be found guilty of a crime unless the state proves its case beyond a reasonable doubt and to a moral certainty. Another principle, which is fundamental to the function of the criminal justice system, is that witnesses must tell the truth. That is, if we have an oath by which an in particular public official puts his hand on the Bible and swears to tell the truth, that public official, police officers in this case, if they lie, they then besmirch the oath, they besmirch the integrity of the system, and the whole system is betrayed. Now, cross-examination may help ferret out the truth. The general rule is that witnesses are presumed to come forward and to tell the truth, and in particular, police officers. Now, I'm a criminal defense lawyer, and so I say to you that right from the beginning, I defend people in very serious cases. In the 25 years that I've practiced law, I've never lost a murder case. I defend. And the only time I sue the police. I say that to you right away. And I sue the police for depriving people of their constitutional rights. I take great relish in suing the police. As I stand here tonight, I will not be surprised that there is another 2 or 3 pages added to my FBI file. I've learned that over the years. And that is, there will be another edition which said, Lennox Hinds came to Naropa Institute, and this is what he said. Also, there will be redaction on that file. On the page, there will be a redaction. It would say, blank reported on November 10th, 1995, that Lennox Hinds said. Why do I say that? I don't want to create any suspicion among the audience. But the reality is this, and I just know this to be a fact, that within our society, there are those of us who have been critics of the established order, and as such, we become targets. Within the adversary system, witnesses who take the stand, and especially police officers, are generally cloaked with a perception of being truthful. And it is hard where you have a police officer saying that you ran the red light and you decide that you're going to fight this ticket because you didn't run a red light. And you get up and the judge is looking at you and he's listening to your statement. And after all is said and done, you and the police officer, after all is said and done, he says, I find you guilty. $25 court costs, $50 fine. And then some of you get up and say, well, I'm guilty with an explanation, as if that is going to change something. And the judge listens to your explanation, gives you the same sentence. The reality that we saw when Furman took the stand is that he made it very clear that he was a racist and incapable and unable to discharge any of his duties neutrally. The actions of a racist cop in any case must be suspect. And Furman reflected hatred, uncontrolled emotions, irrationality, and at the bottom line, lawlessness. There's a famous United States Supreme Court justice by the name of Cardozo, who, as he talked about the need to stop official lawlessness, it was in a landmark case called Olmstead versus the United States. And he said the government is the most omnipotent teacher. Teaches by example. When government officials are perceived to be above the law, and if they can operate above the law, then the general population will lose confidence in the law, and we then invite anarchy. Jurors of any race have legitimate reasons to doubt the integrity of any officer who is proved in court to have lied under oath or to be a racist. Rarely are such officers exposed. Simpson was among the fortunate few to have the money to track down the evidence needed to prove the racial bias and racial animus of the police officers. The prosecution of the Simpson case was doomed from the start. That is, doomed for the prosecution. Not only because it relied on the testimony of at least one overtly racist police officer, but because the prosecution was riddled with the ugly and shoddy tactics that erodes the confidence of members of racial minorities, not only in Los Angeles, but as I've discussed throughout the country. The problem was not only the way the police went about gathering evidence at Mr. Simpson's home the morning after the murders, but also the way the Los Angeles District Attorney's Office subsequently defended these arrogant blunders. At the preliminary hearing, Detectives Philip Van Allen and Mark Furman testified that they and two other officers traveled to Simpson's home at the Rockingham Avenue residence. And they said they went there to inform him of the murder of his wife, so he could make arrangements for his children. They said they didn't think that he was a suspect. They testified that after getting no response to the buzzer, and following the discovery of a small spot of blood on Simpson's Bronco, which was on the street, to jump the wall because they feared for Simpson's safety. Now, this was pure bull. These officers knew that they could not search the premises without at least exigency. There had to be probable cause, a search warrant, but absent a search warrant, they needed some exigent circumstances. The law says that, the Fourth Amendment says that very clearly. The only way that the police can search you without a search warrant is if they arrest you at the time that you commit a crime. So they can search you incident to an unlawful arrest. They can also search you if you consent. That is, police says, step out of your car. Would you please open the trunk? and you foolishly say yes. Or the police knock on your door and they say, "Can I come in?" and you foolishly say yes. All of those are consent. The police also can search or can seize evidence if they see it in plain view. That is, you're stopped while driving on Route 70 or traveling on Pearl Street, and the officer flashes his flashlight in your car, and he sees some insects in your ashtray, roaches, that is. That's plain view. Some of you are smiling and some of you are not. Those of you who simply do not know the local parlance of what a roach is, it is not the insect. Under those circumstances, searches can be made. In the context of the Simpson matter, the police could not have gotten over to find the glove without a warrant. So, we have a judge who is sitting at a preliminary hearing who does not have the courage to call the question as it evolved. Her position is, I'm not suppressing any of this evidence. let the trial judge deal with that. I'm letting everything in. And then we have Ido, who has as much courage as 2 mosquitoes on a scale. Now, Ido certainly is not making any major decisions. And so we have a system where people begin to examine and question, the fairness of what is going on. The detectives went to the Rockingham residence for one reason. They went to question Simpson. And they went to question him before he was able to get himself a lawyer. Perhaps he had an alibi or something, but they were viewing him as a suspect. They didn't need a spot of blood on the Bronco to have powerful reasons to question Simpson. But assuming they did see the blood, why were they checking the car in the first place if they had come to deliver the tragic news? It's clear the cops went over the wall to find Simpson, not to save him. Anyone who has spent any time in the criminal justice system knows that. The fact that the district attorney's office put these officers on a witness stand to tell the story, and the municipal judge at a pretrial hearing, Kathleen Kennedy Powell, accepted it, is scandalous, but it's also routine. Everyone hates the Fourth Amendment, because if the police blunder or falsify the search, the evidence is lost. But the Fourth Amendment was not added to the Constitution to make the police happy. It was intended by the Founding Fathers to protect individuals from the state and to ensure that political minorities would not be the object of random searches engineered by the political majority. Now, a legal system, like any moral system, is a complex and interdependent social arrangement. No one does good on his own. It requires the constant support, reinforcement, and allegiance of all players for each to resist the ever-present temptation to let ends justify the means. And that system broke down in Los Angeles in the Simpson case. But to criticize only Detectives Furman and Van Allen misses the point. It was the Los Angeles District Attorney's Office that put these two characters on the stand. It was Judge Kennedy Powell who took their testimony at face value rather than stir controversy by suppressing the most damning evidence in the case at that time. It was Judge Lance Ito who refused to reverse the decision. Now, because prosecutors routinely accept even the most unlikely stories from police officers, they chose not to recognize that Mr. Furman was a generally bad character. By the time news of Furman's background began to emerge, the prosecutors were joined with him at the hip. He was their star witness, a foul-mouthed racist cop, the latest poster boy of the Los Angeles Police Department, his image hanging on the wall of the public mind next to those of the officers who beat up Rodney King. And the jury made them pay. The jurors were impaneled, knowing from the start, by their life experiences, that this was business as usual in LA. Nothing the prosecution could do could convince them that this case was not corrupted by the police department's world-renowned racial hostility. Who knows how this case could have developed had the authorities played it straight from the start. If Judge Kennedy Powell had said, "I know these police officers want us to believe what they have said, but that defies my sense of reality. This evidence is suppressed." How different would the trial have been if the district attorney's office had conceded that the police had violated Mr. Simpson's rights, but tried to save the evidence that might have been found if the police had gotten a search warrant? Yes, suppressing the glove would have meant headlines. It would have been another blemish on the police department. But it would have been a clarion announcement to the world and to Los Angeles black community that the criminal justice system was trying to mend its ways and was attempting to treat all citizens of Los Angeles fairly. Paradoxically, it would also have given the district attorney's office its best chance to win this case. It would have relieved the jurors, all but two of whom were black or Hispanic, of the troubling choice they ultimately faced between convicting Mr. Simpson or vindicating their own rights, which no one else in the legal system seemed to have bothered to protect. Now, while some will say that Simpson won this case on the grounds of race rather than on evidence, they're incorrect. The racism of the system and the witnesses were part of the evidence, and so too was the lying. Others will say that Simpson's wealth brought him this verdict. These people may be right, but for the wrong reasons. Without his money, Simpson surely would not have had available to him the battery of lawyers or world-renowned experts that he was able to effectively use at trial. Simpson's wealth should not reflect negatively upon him, but rather upon the system and the predicament others are placed in who do not have his means. The indictment is not and should not be on Simpson because of his wealth. The indictment should be on the system. Most people accused of crime do not have anywhere near the resources needed to level the playing field with the state. Does this result in more innocent poor people being found guilty than innocent rich people? What do you think? If you look at who is in jail, most of the people who are in jail are poor. You don't have rich people in the joint, not many. And it isn't because they don't commit crime. The system should be reformed to level the playing field so that race and class are not factors. Race and class should not be the factors that determine the outcome. The system should be reformed so that the AJs, the PJs, the LJs, the BJs would be treated like the OJs. The lessons to be learned from this case are many, and too many to examine here tonight. But there are a few that I think we should reflect on. One, dishonesty and racism should have no place in the democratic justice system. Trials, particularly murder trials, should be conducted with professionalism, solemnity, and dignity. And there should be greater attention paid to the time sacrificed by jurors who serve in the system, whether sequestered or not. And that the deliberative processes of the jury should be respected, even juries that are not all white. The jury did what it believed was right, given the state of the record before it. The jury followed the law, and it followed constitutional principles, the principles that we are taught from our earliest years to follow. It is far more difficult for a jury to acquit a man it believes may have committed a crime than to acquit one who is clearly falsely accused. No jury wants to see a man whom it believes committed a crime go free. But the jury has an obligation to do so if it is not convinced beyond a reasonable doubt that the accusation has been proved. If Simpson did commit these crimes, the blame for him going free must rest with the responsible state officers. The good citizens who sat on this jury, however, who properly discharged their constitutional function, should not be blamed. They should be thanked and commended for the enormous personal sacrifices they had to make to serve as jurors, and for the difficult decision that few in their shoes would have liked to have made. They, more than most, believe in the Constitution. Thank you for joining me in this discussion. Any questions? I just looked at my watch and I was startled at, say, 11 o'clock, but it's the New York Times.
Yes. So what are the solutions to this situation of the racism in our legal system? I mean, how, being that it's 200 years old, 220 years old, what do we do to change it, to level the playing field?
Well, I think that this is the answer to this question is not to come from this podium, but it has to come from you. It has to come from you as you, in fact, go to the polling booth. The people whom you elect as your prosecutors, the people whom you elect as your legislators, even starting at the local level, at the municipal level, who are in fact passing ordinances. How many minorities do you have on your local city council here? All right. Did you have a chance most recently to do something about it earlier this week? All right. The point I am making is that we have to start where we are in changing how we function and who makes decisions and what those decisions are. If judges are elected, then who are the people who are running? What do they stand for? Similarly, if you're dealing with individuals who are appointing, if you have an appointed system where judges are appointed, then who are the politicians making those decisions? Do you have any control over those? And then the laws that are passed. Many of us believe that by passing more repressive laws, we will, in fact, cut down on crime. I have a law office which is located in Harlem, in New York City. across the street from my law office, there is a drugstore. By drugstore, I do not mean a store where prescription drugs are sold. There is drug trafficking going on. The police in that precinct know where all of the drugstores are. We have to constantly struggle in order to have these people removed from the streets. Now, if we are, and I start from where I am. I've organized the block. We take young kids right off the street. They come into my law office. We take them to court. We, as lawyers, and we also are training people in the community on parliamentary procedures in terms of holding meetings and so on and so forth, so that they begin to change the quality of life on that block. You start from where you are. And the solutions, if we are looking for the solutions to come from here, that is a mistake. I think we have to identify the problems, be prepared to discuss them openly, and then say, how can we change them? Many of us, because we do not want to be forced to share our wealth, that is, with someone out on the streets who may be climbing in your car window as you're sitting in here. Nobody wants that. All right? If you want, you certainly want voluntarily to distribute your wealth, but you don't want it to be taken from you. And so therefore we buy into the contract on America. And we say that, we want to increase sentences, and we want to increase the number of crimes, and we want to make sure that there are 3 strikes and you're in, and on and on and on. It's in frustration, without analyzing that none of these schemes are reducing crime. Because if you look at the relationship between unemployment and criminal activity, you see that as the unemployment rate goes up, the level of street crime also goes up. But we are not prepared to make the social investment that is necessary. And so therefore we're investing in the prison industry. But unless we decide that we're simply going to hand out life imprisonment for all offenses, or execute more and more people, those we send away are going to come back out. Yes?
Yeah, you made a quote at the beginning of your talk from Du Bois.
Oh, yes.
I thank you for that. And during your talk, you have also, as Du Bois did, made a connection, I believe, between racism and class struggle in this country. Do you find it rather interesting that perhaps that during this year, while Americans were being entertained with the partial lynching of a nigger in a white shirt, that the same people who were being entertained by that, working class people like myself, were taking another notch down on the ladder, while the people who planned and orchestrated the whole game, the whole show, were having one of the best years they've ever had?
Sure. Gentleman is, and I think correctly noting that the trial that we became so infatuated with, that we couldn't turn away from, that we couldn't escape, so to speak, which was more of a soap opera. People were tuning into it on a daily basis. It was used like a major sedative in the backsides of working people, because while we were being entertained at that level, there were all of these plans and schemes to take away working people's rights in so many areas. And the Simpson trial certainly was quite a diversion in this respect. Yes, sir.
Just curious about how you see the direction of the Supreme Court in the next 10 to 15 years.
I happen to believe, and most of my work at this point is attempting to think about alternative strategies for obtaining relief for human rights violations domestically in the United States, other than relying upon the United States Supreme Court. I do not happen to believe that we're going to have much relief over the next 15 years. I think that between Uncle Thomas and Anthony Scalia, there's been an ideological shift in the court that anyone who happened to think that you could get some relief in the court have to think otherwise. And so therefore I've been looking at international relief, either looking at the possibilities of the International Court of Justice or looking at the United Nations, and thinking about ways in which the United States could be forced, embarrassed in many respects, by hanging its dirty linen out into the international community. I happen to have brought a major complaint in 1979 at the UN, and I presented a case in Geneva where we pointed out how the criminal justice system has been used in the basic race and class bias within the criminal justice system. But we were focusing on the treatment of national minorities. And I think that that is a way that I am thinking of going. I don't happen to think that we are going to get much relief before the United States Supreme Court. There may be some shots that we can get by getting some relief, perhaps under some state, some progressive state courts, but I do not hold much hope in the United States Supreme Court. Yes, sir, in the back.
My question is, do you think America is ready for a Colin Powell president?
I found Colin Powell's reading in the media to be very, very interesting, and I must say that I am a cynic. So therefore, I wondered how truthful it was. In terms of those people who were polled and indicated that they would vote for him over a fellow who is now in office, who's called Slick Willie. Um, the reality, though, is that I think that Colin Powell would be an acceptable candidate if he was prepared to run the agenda of some of his handlers. What do I mean by that? Look at Clarence Thomas. Clarence Thomas was, there was a great battle that took place within the Senate. And if you look at the people who were supporting Clarence Thomas, Jesse Helms is one of his strongest supporters. Why? Because Clarence, notwithstanding the color of his skin, was prepared to carry out the game plan of his handlers to the detriment of poor, working class, and black people. And so therefore, if Colin Powell is prepared, or was prepared, to play a particular role, I think there would be no problem with those who are the opinion makers and power brokers representing the ruling class to push it. Yes, ma'am.
I would like to shift the focus temporarily and ask you, if you would, to consider sharing whatever insights you might have about the status of South Africa.
South Africa. I've spent a considerable amount of time over the last 5 years. Well, I've been the lawyer for the ANC for 20 years, but over the last 5 years I've spent a considerable amount of time with the ANC leadership, dealing with the troubling problems of moving from liberation movement to government in power. The story in South Africa is still unfolding. Mr. Mandela and his cabinet and ANC leadership face a tremendous challenge. In reality, they compromised with the whites who were in power. And so therefore, what is in place right now in South Africa is a system where the white minority were guaranteed the status quo to the extent that they were guaranteed they would not lose their jobs. They would continue to have houses, pools, and other things, that all of the appurtenances of power that they had. The ANC would take the reins of the government. If any whites were sacked, they then had to be compensated. And so therefore, and furthermore, the clerk, before he left office, put in a safety net of $8.5 billion to underwrite all of the white bureaucrats in terms of their pensions, which the Mandela government now has to pay. Whites have bought into this process because they have given up very little. The ANC have said to them, look, we want you to agree with us that in the future, you will help everyone row in this boat that we're in. We're not taking anything away from you, but we want you to give us assurances that you will not continue to suppress the 25 to 30 million blacks who are in the society. And they have said solid. Right on. They maintain all of the top positions in the military, except Joe Medici Shaw is Minister of Defense. He was the Commander-in-Chief of Umkhonto Wesizwe. But all of his lieutenants, all of the generals under him, all of the admirals in the Navy are white. So what the ANC's plan is within 5 years is to develop a new category.